professional body that has a broad footprint across the cultural and creative sector. And the primary topic of discussion this morning is going to be the new legislation introduced by the Department of Employment and Labour, or draft legislation at this stage, that focuses on redefining various people that work in the kind of entertainment industry as employees for certain conditions of the Basic Conditions of Employment Act, and the basis of this is to eliminate abuse and exploitation. I think that what we have seen over many years is unscrupulous promoters and producers abusing and exploiting individuals working in the sector, requiring them to work ridiculously long hours. We've seen it in the events industry particularly, where performers turn up, or tech crew in particular turn up. They have to build a set, they have quick turnaround, and then they have to manage the sound and the light and everything else that happens within the performance. And then they have to strike the structures, and they end up working 24 hours straight without any kind of break, often without any kind of allowance for food. It's just a terrible situation. Now, I don't want to suggest everybody in the entertainment industry abuses and exploits staff, and in particular freelancers. There are some very reputable production companies and promoters that actually treat their freelance staff really well. But we have always had a few bad apples that rot the barrel and impact everybody else. And I think what we're looking at now is a situation where we have new legislation that has been proposed by the Department of Employment and Labour as a direct result of that continued exploitation and abuse. It's not something that we addressed ourselves, and so government has stepped in and is imposing a solution upon us. Personally, I think it's great legislation. I would like to see it expanded to include tech crew, because at the moment it refers specifically to performers. But this is really what breakfast is all about. It's an opportunity to engage directly with the department, to learn more about the legislation, the logic behind its introduction, and actually just to talk with each other about what the practical implications of this legislation are. So our first speaker is Mr. Mkhalipi from Department of Employment and Labour. We've had many conversations with the department over an extended period of time, and so he's going to be our first speaker, talking about what this legislation is, where it's come from, why there is a need for it. Following that, we're going to have some input from Jack Devnarain. Jack has been a champion for workers' rights, particularly for actors working across film, television, theatre. But actually Jack has been working with SACIA and with other professional bodies and associations in the sector, not just to focus on the situation that the actors find themselves in, but many other stakeholders working in the cultural and creative industry. Then our sponsor, one of our sponsors for the breakfast this morning, the South African Audiovisual Cluster. So Simon is going to be talking to us very briefly about the South African Audiovisual Cluster, who they are, new association on the block. So who they are, what they do, and why we have partnered with them to drive communication across the audiovisual industry. And then we're going to finish up with a presentation by Aldred Dreyer, immediate past chair of our broadcast industry group, who's going to be talking about digital radio and new developments in digital radio. And he's brought along a, what do we call it? A receiver. Okay, he's brought along a receiver to demonstrate what the latest technology is in terms of digital radio in South Africa. So we've got a kind of a lot of ground to cover. I want to suggest that after each of our speakers, we're going to take a break. There will be plenty of opportunities for questions. This is not about stand-up presentations. This is about an opportunity to engage, to interact, to chat, to discuss. If you want to argue, you're welcome to argue as well. You know, this is really a learning opportunity, so thank you very much for joining us for our breakfast. And Mr. Mkhilipi.
And what we expect from the sector, I mean, the whole sector. We've had discussion, and I think we've ratified certain conventions in terms of the International Labour Organization, Convention on Freedom of Association, the right to organize, and we've looked at international best practice in the sector, what's happening in the sector, what is the status of the workers in the sector. We look at that and compare with what's the situation in South Africa. South Africa got two problems. Is that the workers in the sector want protection in terms of labor law, but they still want to benefit in terms of tax incentive as independent business people. You can't have it both ways. We need to put that up front, that as employees, you tax differently. As independent contractors, business people, you tax differently. Now, you'll have that discussion with the tax person, the tax man, not with us. We don't deal with tax. We deal with this issue on employer-employee relationship. And we're not only concerned about this sector. Yes, in terms of the notice, it talked to this sector. We're concerned about a number of sectors in the labor market with labor law does not protect them. The Ubers of this world, 60s, gig economy, and all of those. Now, in the last discussion that we had at Network and online, the stakeholders made a clear preference of self-determination, social dialogue, that they want to set social dialogue on their own and set up their own condition. Nothing has happened since then. And because of that no movement on the issues around self-determination, as a department, then we started the process. We're doing two processes at the same time. The first process that we're doing today, as I'm speaking, at around about, after lunch, I think after lunch, around about 1, the bills amending the LRA, the BCA, employment equity, the national minimum wage will be published today for public comment. Now, what is crucial in those bills, even if you don't read anything else, you look at the definition of an employee. We're amending the definition of the employee so that workers working in this sector and the other sectors in gig economy are regarded as employee in terms of the Labour Relations Act, the BCA, national minimum wage, and other legislation. That's the bigger change that we are making. Because we realize and accept that because we are a constitutional democracy, legislation making take a little bit long in our country. It's unlike in America where the president can just decree, and it doesn't matter, decree a law and it becomes a law. That's not how we work here. President does not have that authority. Only Parliament can make a law. And in terms of the Constitution, there's a long process, consultation, and all of these things that you need to go through to make a law. That's our democracy. I'm sure, our former president did ask if he can be a detective one day. He might be able to solve many things. We don't know about that. Therefore, in terms of the long term, we are amending the LRA and the BCA to deal with the definition of an employee. That definition that we put in is going to cover every employee. Therefore, even workers in this industry will have protection against that definition. That's the second thing that we've done for the second time. Remember, we published when Mnesi was 2019, when Mnesi was a minister, the same notice, published a notice, and then as a result of that notice, we had the discussion that we had with the sector, because we published just notice, and there was an issue raised by the sector that we want self-determination and all those issues. Then we republished the notice again. The notice is simple. It says the minister intend to deem workers in the performing arts. What performing arts is, how is it defined? The notice does not define that. With that, the minister has also written a letter to the National Minimum Wage Commission and asked the National Minimum Wage Commission to investigate conditions in this sector. That's what the law requires. If you look at the BCA, the minister has got to ask the commission, and that might lead to a sectoral determination being published that protect workers. And that sectoral determination will then define, it's going to probably be published just like the notice is published. It's going to be published that the commission is asking for public comments on the possible introduction of a sectoral determination to protect workers in performing arts sector. And it's going to have a definition of what we take as the performing arts sector. Remember, we are just bureaucrats. We don't know your sector. We don't know where it starts, where it ends. We're no expert on that. We expert in making laws and regulation. That's our responsibility. But we will put a definition that we thought about and put it in the sectoral definition. It's for you guys in the sector, workers and employers, to make proposal, comment on that, whether the definition is wide enough, whether is it too wide, whether is it too narrow. Now, the sectoral determination can only be published if the minister deemed the workers as employees, because sectoral determination covers employees only. Therefore, the first thing is the minister has got to make up her mind based on the comments that have been received, whether she's going to continue with the deeming provision. If, for whatever reason, the minister does not continue, I'm not saying that's what's going to happen. The LRA and the BCA amendment will still do the same, but take a bit longer. Now, if the minister agreed to deem the workers in this sector as employees, also that will have to have a clear definition who is covered, who's not covered in terms of that. And then the commission will publish the protection that will be covered in the sectoral determination. It's not going to cover wages. We're not talking about wages. And our approach is that we're hoping that this initiative will move the impetus towards collective bargaining in the sector. We don't prefer to publish a sectoral determination. But if there's no move on these areas, as government, we can't sit and not do anything. Therefore, parties in this sector, both workers and employers, have got a decision to make. Do you want to determine your own density, or do you want bureaucrats who know nothing about your sector to determine conditions your sector. That's a decision that you make, yourself need to make. The other issue that is important for workers in the sector is that you must understand that we make legislation, only workers that have got organizations that are well capacitated to protect those workers benefit in legislation. If you look at the South African labor landscape, the most vulnerable sectors are those that don't have worker organization protecting them. Look at the domestic workers, farm workers. All of those sectors that do not have trade unions or whatever form of organization representing them, they tend to be at the bottom of the ladder. Those sectors that have got representativity that represent workers' interests, they are able to uplift the standard of living of those workers. Government is not going to do it for you, just like we do not do it for other workers in the metal industry, in the chemical industry. We set up legislation and give them the opportunity to form organizations to protect themselves. Therefore, workers in this sector have got to start thinking seriously about how are they going to use the space that has been created by the deeming provision, by the sectoral determination, to build protections for themselves in consultation with employers in the sector. Obviously, it's in the interest of employers in the sector that there should be some uniformity. You don't want one employer paying the lowest wages and out-competing others who want to do the right thing. And that's what social dialogue and collective bargaining solve, so that competition between business people, employers, is fair. You don't get business because you pay the lowest wage. You get business because you're good at what you do. And that's our approach in these issues. Therefore, as I've said today, by 1-2, the bills for public comment will be out. You can, I'm not saying don't read the whole bills. You can read all of them, but what will interest you more is the definition, the change in the definition of employee that is being proposed in the bills, all of them. Even the UIF bill that will be published is going to have that change. You'll be able to contribute to UIF and claim UIF as employees when you lose your contract, you lose your job, you're not working. Even COIDA, compensation, safety, you'll be covered by that. It's going to have the same definition. The sectoral determination that might be published. Remember, these things are on the pipeline. They all depend on what the minister decides. It will give protection on COIDA, UIF. We've listed the legislation in terms of the areas that we need to have immediate protection. And therefore, that's the road that we will hopefully travel together in terms of this. Now, we are going to be looking from next week, analyzing the comments that we've received on the deeming provision. We've received comments, the date. I hope you guys commented. I don't know what you said, but hope. And we're going to analyze the comment and make a recommendation for the minister to make a decision. Obviously, the decision is going to be based on the comment. It's going to be based on the issue that I've raised, the international best practice of what's happening in the sector, how workers are treated in other countries in the sector. It's going to be based also on our commitment as a country towards what we signed on in terms of our international obligation. Those are the three issues that will determine which way we go. And if the minister agrees to deem, then the notice from the commission will be published immediately, where the commission says, we intend to introduce a sectoral determination for this sector. This is how we define it. This is a protection that will be given by that sectoral determination. We don't have to finalize that process. Parties in the sector have got an opportunity to say, well, let's sit down and talk about whether the issues in the sectoral definition should be in, whether they are enough, is anything that we've left off, and try and buy in on the process so that if a sectoral definition is introduced at some stage, they are able to say, no, we negotiated that document. We all accept it. And then that's basically the issue. We've got nothing to add on what we publish in terms of the notice, in terms of, I've given you the roadmap in terms of what we intend to do. If all goes well, we think the minister, before the end of March, should be able to publish her final view on whether to deem or not to deem. If that happens, then before the end of March, the sectoral determination, which is content, will be published for public comment. And as I've said, the bills for public comment to amend the definition of an employee are coming out today. And we hope that by April, those bills should be in Parliament. And even there, it's in your interest in the sector, both employers and employees, whether you support it or not. We are a democracy and transparent on these issues. You've got the right to make your views whatever way you want to make them, with the department, with the parliamentarians who makes the law. Have I missed up anything? If there are any questions and clarification, we'll take them. Thank you very much.
Ask.
Greetings, everyone. My name is Gustav Lenzwe. I'm with the SABC. I'm the operations manager there. So I do a lot of recruiting on freelancers. And I foresee a challenge with the blanket approach we seem to be thinking here in terms of defining an employee or giving an employee status. I'd much rather suggest that maybe there's different criteria of employees. Reason being, I've been in this industry for a long time, and people have different preferences. Most independent contractors, they prefer autonomy. They prefer working for several employers, They prefer not to be grounded by the bureaucracy of the corporate world, if I may put it that way. In fact, I've got 2 employees who are resigning because they want to be freelancers, which they deem to be preferable, You spoke about the payment rates and what's the best practice internationally. At SABC, the rate card that we use is based on the rates used on employees. So, for example, if you're a camera operator, senior camera operator, as a permanent, when you become a freelance, there's a certain range that we use, and shouldn't be far out, from that of the permanent, But because of this autonomy and flexibility, people seem to think they make more money with the freelance, because now under the employee code, your salary is then subdivided into UIF, into this, into medical aid, when you prefer to be doing it yourself in your own way, And we've had freelancers who joined the permanent status and went back to freelancing. They're like, no, this doesn't suit us at all. So the blanket approach, for me, is going to give us a problem, unless we categorize it in that sense, that, okay, the employee status that we give into independent contractors is going to be 1, 2, 3, and it will benefit them, Like, for example, if I were to make an example, freelancers do not qualify for, they have to bring their own PPEs, safety equipment. They have to bring their own tools of trade. But at SABC, we provide tools of trade for them. But according to their contract, they're supposed to, you know what I mean? But because of broadcast continuity and things like that, we provide it for them. Even in some cases, we do with PPEs, because otherwise someone will just fold their arms and say, I'm not going there. You know, you didn't tell me beforehand that we're gonna climb on top of the roof of the stadium, you know? So we've got those gadgets ready and equipment ready for them to say, hey, no, it's okay. Yeah, you know what I mean? So the blanket approach, that's what I've got a problem with. I think we need to relook at it and approach it differently in terms of different categories like that. Thank you.
When you make this statement, I mean, that says, well, we don't want a blanket approach. It's the same statement that many people make and say, well, our labor laws are inflexible, and they end there. Now, I don't know what it means, blanket approach. I mean, do you want a law that says for you, it covers you, it doesn't cover you? You can't have that. That's the first issue. A law covers all workers, labor law. You can't have labor law that covers A, doesn't cover B. That's the first issue. How you, as a company, will not foresee a law that will determine what rate you pay. That's why I said up front that we don't want to go into the rate of pay on this issue. But should freelancers be protected against injury? Should freelancers be protected against working long hours with no rest? Should freelancers be protected against unemployment? If COVID-2 hits, we close again. Is SABC going to continue? Other workers are going to get paid out of unemployment. Will you continue paying your freelancers because they're not part of unemployment? And the approach should be, you make laws to protect you. I normally say to my colleagues, labor, when we negotiate at NetLeg, you make laws to protect you when your enemies are in power, not when your friends are in power. Just think, when your enemies are in power, if you do not have laws to protect you, the same applies in this situation. If the freelancers are not protected, as you say, who's going to pay them when we close our economy because we've got Therefore, our approach is not to change the relationship. Just like you have domestic workers who work for 5 employers. It's not only them, they work for 5 employers. Even with the laws protecting them, they can work for 5 employers. They can do that. It's a relationship between you and them. I can't work for 5 employers because my employer says, you are mine, you work for me. If you are going to do anything outside this, you must have my permission. That's what my employer says. But if SABC is not saying that to freelancers and say, you're going to be protected, you're not going to work unnecessary long hours here. You're going to be protected against danger here. You're going to be protected on those issues that employees are protected in, but you are not our employee. And this is the amount of work that hours that will give you. Just like, I mean, if you go at ShopRite, Woolworths, and see you guys, you all shop at Woolworths. You don't shop at you don't shop at ShopRite. Ask civil servants shop at ShopRite. The people that are serving you there are called on-call workers. They're not employed permanently. They are about 50% of the workers working in the retail are there because they are on call. They don't have permanent contract. They are on call. And you see in the bills that we are introducing, we're introducing protection for those workers also. Therefore, you're not unique in that kind of relationship with your employees. And those employees have got a protection. The workers working for seasonal in the farms, they are not. They come in when the fruit is ripe to be harvested, or your what they come in for that time. It's the same thing with freelance, same principle that we talk about. Therefore, when we talk about protection, it does not change the nature of the contract that you've entered with. It does not make them all of a sudden permanent. No, it doesn't. That's also, if you look at international best practice, I mean, if you look at Canada, US, Europe, workers working in the sector are treated the same way. They've got protection of labor law, but they still remain freelancers. The relationship is regulated by the agreement between the parties. And the rate, that's why we're not saying, I mean, these workers, we're assuming that they are getting more than the minimum wage. The minimum wage is not going to be an issue to them. The contract that you enter with them will determine what they get paid. Therefore, for me, what will help us, when you say we don't want, what is the term that you use, blanket, you need to go further than that, not end the experience. What do you mean about blanket? What does that mean? How does it change the protection given to the workers in there? Are you looking at a situation that you'll have two people, this one will have protection, that one won't have protection? Is it wrong to give blanket protection? And maybe the deeming itself, let's demystify this issue. Deeming does not really give protection. It just gives you a status. What gives you protection will be the sectoral determination that will determine what protections are these workers protected, in which legislation are they covered with. That will determine the protection that they get. The deeming itself is just a process to put them in the law. It does not give any protection. And I think it's important that we understand the architect and the way our legislation works. As I've said, the deeming is just a key to enable us to be able, if we need. Doesn't necessarily mean that we are going to have a sectoral determination. We can listen to your comments and decide that, no, you don't need this protection. You can protect yourself, whatever, I don't know. But it is a key to enable to provide the protection. That's what deeming is. On its own, it's not protection. I'm not sure whether we are together, SABC.
My name is Melvin. I am one of the chairs of the DSAC clusters, similar to audiovisual. I do the books and publishing. So the question is around, following on to the previous question, is really around what is defined as a person engaged in performing arts. So, because that could be any number of things. I mean, there's actors, yes, Jack will talk about that, but there's comedians, there's stage presence, opera, there's a whole lot of things. When I take off my hat, publishing and books, which I've been wearing for 15 years, and go back to when I was a general manager in EdCon, we had things called permanent part-timers and flexible part-timers, which we came up with ourselves in retail operations, because we needed something to make sure that we would have sufficient labor for certain periods, your festive season, etc. I was obviously on the management side during that aspect, and now I'm seeing myself on the receiving end of what could be a disaster if we left it up to industry to decide what's going to happen to people in performing arts. I think that's the substance of the question that Simon has asked me to ask, is beyond, first of all, what is the definition of that performing arts, and I suppose covering the comedians and the opera singers and the rest of them. We're maybe trying to get a clue into what that employee definition is actually going to be.
Hi, I'm Denise Hatting. We do short-term insurance for the entertainment industry. So my question is, are you specifically looking at child artists outside of the scope, or is there a specific definition for them? Second to that, stunts, special effects. So the person who willingly jumps off the building or does a body burn. Is there a specific section created for those two industries? Thank you.
This question, I mean, it's a similar question that you're raising, that is raising. I've answered up front. You've got to decide, do you want bureaucrats to define the sector? The reason we publish these things for public comment is exactly that. For you to comment, what do you think should be the definition of the sector? And you are better placed than us to make your suggestion, so that you can we'll put a wording out there and say, this is what we think. But we're saying upfront, because we're not part of the industry. What we know in the industry is what we see on the TV, nothing else. And therefore, our understanding on the industry might be limited. And that's what public comments are there for. But if the industry doesn't comment, does not enrich whatever document that we put on the table, then garbage in, garbage out. That's how it works.
Good morning. Natalie Rasmus from Safeguard Africa. We are a health and safety consultancy within the creative spaces. We do a lot of film and TV work, a lot of live events work. My question was, in terms of once these new definitions, once these new legislations, all of that come into play, will the department be engaging with other sectors, such as the Occupational Health and Safety Act, those sectors of government, to encourage the same sort of coverage for people within the creative spaces? The reason why I'm asking is we know a lot of film productions get around needing to comply to the OHS because 80% of their staff or of their crew are freelancers. Therefore, they're not deemed as employees. Therefore, they don't need to put into place the same sort of strict health and safety rules that a normal workplace would do.
Again, I've dealt with this issue. We must look at the definition of an employee in the bills that we're going to publish today for public comment. That definition, the change in that definition, solves that problem. Secondly, the deeming provision, talking to this sector, the deeming provision, when you are deemed as employees, we said that opens the door for a possible sectoral determination. And that sectoral determination could say that workers in these sectors are covered by occupational health and safety, by UIF, by all sorts of legislation. I can't say that's what it will say. You'll see when it is published with its recommendation. But what I'm saying, the issue that they are raising already covered by the definition of employee in the LRA, BCA, and the other legislation, and the possible sectoral determination to cover because of the time it will take to have the law amended, sectoral determination, if the deeming provision goes through, will deal with that issue, will give that coverage for UI, occupational health and safety, and all of that stuff. The issue will be, is the definition in the sectoral determination covering wide enough to cover everybody? That's the issue that you need to look at.